Hi friends, I am Advocate Namish Nigotia and you are watching my YouTube channel Legal Advice for Everyone. Friends, many times it happens that civil dispute is pending and in fact there is a civil dispute between the parties, but one party in order to harass the other party used to launch an FIR. Then what is the remedies of available to that person? How can that false criminal prosecution can be quashed and set aside? Whether the Honorable High Court can quash and set aside the first information report under Section 482 of the Code of Criminal Procedure, we would like to study these aspects in this video. Before I start my video, I would like to request that if you have yet not subscribed my channel, please do subscribe my channel, and if you like my videos, please like and share my videos. Friends, today's word, many times it happens that in a civil dispute which is already pending between the parties, one party used to file or launch a first information report. It generally happens in a case of 406, 420, 467, 468, 471 of the Indian Penal Code. Many times it happens that in matrimonial dispute, the wife falsely registered FIR under Section 498A of the Indian Penal Code in order to harass the husband petitioner. Then what are the remedies available and what should the other person or a sufferer should do in order to safeguard his interest and in order to quash the proceedings? Sir, first step the person has to do is to obtain the certified copy of the first information report. How can it be obtained? I have made a detailed video. What is the procedure to obtain the certified copy? You have to apply before the competent magistrate to obtain the certified copy, and after following the procedure, the competent magistrate will provide you the certified copy. Go through the contents of the first information report. Then what is the next step? The next step is you have to go to the investigating officer, approach the investigating officer and file a detailed representation. In that representation, you have to state that, sir, this is a totally false case. Actually, it is a civil dispute. The civil litigation is already pending. If any, you have to file the certified copy if already any civil dispute is pending between the parties. If the complainant has lodged the FIR, then you, being the accused, who are not actually accused, have to contest that case by filing representation before the investigation officer. Supposingly, the investigating officer is also in connivance with the complainant, then what is the remedy or recourse available to you? Then the second remedy is that you have to also supply a copy of the representation to the superintendent of police of concerned area under which the police station or investigating officer is working. If the office of superintendent of police is not available, then you can supply copy of representation to the other superior officers like DYSP, like circle officer, and you have to state that, sir, this is a false case, false FIR has been registered, and the investigating officer in connivance of the complainant is harassing me. So kindly instruct the investigating officer to do the investigation in accordance with law. You have to supply all the documents like first information report, like the certified copies of the civil suit if the pending. If the notices of recovery has been exchanged by the lawyers of the parties, you have to also supply one set of copy of all the documents to the superintendent of police. Please do not forget to obtain the receipt from the office of the superintendent of police. If you think that investigation officer is not doing the proper investigation, like he is not obtaining the witnesses to whom he is required to obtain the witness under Section 161 Cr.P.C, or he is totally in connivance with the complainant, or investigating the entirely false case, then you can make a representation to the superintendent of police by saying that, sir, kindly change the investigation officer. Then the superintendent of police may change the IO, and the newly appointed IO may investigate properly. Supposingly you are not getting any remedy from the police, from the superintendent of police, then what is the recourse available to you? Then you have to approach the Honorable High Court under Section 482 of the Code of Criminal Procedure by filing a petition how to file the 482 petition, I have made a detailed video how to file the 482 petition. In 482 petition, you have to state that the false FIR has been registered. In fact, there is a civil dispute between the parties. You also annexed all the documents before the Honorable High Court, like first information report, like certified copies of the civil dispute, like the representations you have supplied to the investigation officer and superintendent of police. And don't forget that while supplying a representation to the investigation officer and superintendent of police, one copy should also be sent through a registered post, so that if you file the first 482 petition before the Honorable High Court, you are having a cogent proof that you have supplied the representation. Many times it happens that you supplied the representation, but they do not attach it in the case diary, and your representation is nothing but a waste paper before the police station. So you don't forget to send the representation through the registered post. Then the question arises, what ground should be taken in the 482 petition? So you have to state that the police is in connivance with the complainant. There is a civil dispute. As such, the alleged offense has never committed by the person, but totally false allegation has been implemented in the FIR, and the police officer is harassing the petitioner. You have to also state that the Honorable Court may take cognizance of the matter and may quash and set aside the first information report. And you have to submit all the documents on the record before the High Court, so that High Court may take the cognizance and may give the direction to the police officer and may stop the further proceedings, or finally while allowing the petition, the High Court may quash and set aside the first information report. Now we would like to study 3-4 important judgments regarding 482 petition. Honorable Supreme Court in SLP number 8989/2010 decided on 24th of September 2012. Title is Gyan Singh versus State of Punjab, has laid down the principles that on what grounds the FIR should be quashed by the Honorable High Court, and what Honorable High Court should, what are the parameters that Honorable High Court should follow while quashing the FIR. I would like to read. Inherent power is of wide plenitude with no statutory limitation, but it has to be exercised in accordance with the guidelines enlarged in such powers wise. What are the guidelines? To secure the ends of justice or to prevent abuse of the process of any court. If the prosecution is abuse of the court, then the High Court may exercise inherent jurisdiction which is provided under section 482 of the Code of Criminal Procedure. Now the next judgment is also very important, which has been by the Rajasthan High Court, Honorable Rajasthan High Court, delivered in SB Criminal Misdemeanor Petition number 986/1990. It is decided on 29th of January 1997. In this case, the title is Bhupulari Chinna versus State of Rajasthan. That what happened in this case, civil litigation was already pending. Then the one person has filed the first information report. Then the prosecution has been quashed by the Honorable Rajasthan High Court by holding that civil dispute is already pending and it is only the abuse of the process of the court. One judgment, very important judgment, has been delivered by Honorable Gujarat High Court. The title is Swaraj Panari versus State of Gujarat, and it has been decided on 31st of May 2021. It's a latest judgment. Quashing of FIR. What happened? That dispute related to the sale of land. The money was not entirely paid. One party has lost the FIR. Honorable Gujarat High Court says that it is nothing but a civil dispute and it is an abuse of the process of law. So by these methods, you can seek the remedy available to you if a false FIR has been registered. I would like to end this video. Thank you so much, friends.